Oh, I'm William Schabas. I'm the professor of international law at Middlesex University. I am regularly writing and lecturing on subjects of international law. And I'm also somewhat of a practitioner of international law because I have appeared before international courts and tribunals such as the UN Court, the International Court of Justice, and the European Court of Human Rights. And I'm also called upon by governments, by individuals, by organizations to advise them, to give them opinions about the status of public international law and what they, how they should react and how they should address it. You know, you've had an introductory lecture that's spoken a little bit about the origins of international law and about its nature. Someone once said, I think an American scholar said that rules of international law were respected by 99% of countries about 99% of the time. And so it's important to bear in mind that we're looking at a system of how states basically get along with each other, how they resolve problems and how they address issues of mutual interest. And that generally it works rather smoothly. We see, of course, in the courts, the disputes. That's what happens. That's what lawyers are for, largely, is to help to address those disputes. And often there will be cases where there are two different interpretations, and one side and the other, or where there's one side is just defying the law. That doesn't happen often, but that's also the case. But most of the time, states aren't really quarreling about what their obligations are under international law, and they're governing their conduct based on the rules that they understand. So what we need to do, and what this class is about, is the sources of those rules. I'm going to be teaching you about some other things later in the term, but today's class is about the sources of international law. And I am going to break it up into three sort of bite-sized chunks of approximately 15 minutes or so. And the idea is that you're to watch all of these segments before we have our online live class with questions and answers. You don't have to watch them all at the same time, but you need to watch them all before we actually have the class. So let me start by introducing the subject with what is the main text that sets out the sources of public international law. I'm just going to go onto screen share, and I'll show you the text. That's not the one, this is the one, the Statute of the International Court of Justice. Here, I'm going to put this on the full screen. This is an Article 38 from the Statute of the International Court of Justice, which is the United Nations Court. It's the primary judicial institution of the United Nations, and it is the main court where states go to settle their disputes. It was created in 1946, somewhat on the ashes of the Permanent Court of International Justice, which had been set up exactly 100 years ago from now in 1920. And the Permanent Court of International Justice also had a provision identical to this Article 38 of the Statute of the International Court of Justice. They just took it, cut and pasted it into the Statute of the International Court of Justice. So the text we're looking at is 100 years old. It does define the sources that the International Court of Justice is to apply and to decide, to base its decisions upon, but it's also viewed as being an authoritative statement of the sources of international law more generally. And you can see the statutes of other international courts. Think of the European Court of Human Rights. It doesn't have a provision like this. And the judges of the European Court of Human Rights will say, well, we don't apply international conventions generally. We don't apply international custom. We just apply the European Convention of Human Rights. Now, that's not quite true, because they will look at other sources of international law. But in terms of rendering judgments, they will just, the European Court of Human Rights can only decide whether or not there's a violation of the European Convention on Human Rights. Whereas the International Court of Justice has the possibility of ruling that there's a violation of an international convention, international custom, these other sources of law. It's not an exhaustive statement of the law. There are references in the literature, in the textbook, for example, to other sources, but that are of minor importance, really. One of them is a unilateral declaration by a state. Another is resolutions of international bodies like the United Nations General Assembly. These are the main ones. This is the authoritative statement. And of the four, you can see there are 4 paragraphs. The final paragraph is called a subsidiary means for the determination of rules of law. So paragraph D isn't really even a source of law in a way. The first 3 are more clearly identified as sources. And it's the first 2 that are really the more important. The third one is much more secondary in nature. I would not like you to be overly obsessed with the idea that some rules of law are binding and other rules of law are not binding. I find this to be often a very unproductive conversation. To, that all rules are binding if they're law. That's law by its very nature. And while there are formal ways in which we can identify rules of law, such as by a treaty, which is just like a contract between states, or custom, which is somewhat analogous to a common law. It's rules that have evolved of conduct, although they're not codified in a written document necessarily. These are rules created by states and that they apply and that they abide by and that the court will enforce. But there are other rules of law. Sometimes we use the term soft law to in this respect, and soft law is also a source of law. It may not be enforceable before a court, but it doesn't mean that it doesn't guarantee, that it doesn't govern conduct by states and that they don't behave as if they have an obligation to respect it. So we could give examples of this. We have things like the United Nations Declaration on Indigenous, the rights of Indigenous persons and of Indigenous peoples. And it sets out a number of rules that are not, technically speaking, enforceable by a court, but courts will refer to them and states will largely abide by them. So I consider them to be law as well. But it is certainly something that is maybe less analogous to what we're familiar with at the national level in terms of national law. There are many analogies between international law and national law, but you can see them. I'm not going to dwell on them. The one source here that is probably closest to national law is paragraph C, which refers to the general principles of law recognized by civilized nations. I'm sorry about that expression, civilized nations. This was written 100 years ago. That's the way they spoke then. But the notion of general principles of law is certainly valid today as it was 100 years ago. We just would say general principles of law. The idea being that paragraph C is derived by a kind of deductive process from national law, whereas paragraphs A and B are created at the international level. Treaties, international conventions. The word conventions is synonymous with treaties. These are agreements. They're like contracts between states, and they can be bilateral in the sense that they're an agreement between 2 states or a state and an international organization, or they can be multilateral when they are adopted by many, many states. So a good recent example of a bilateral international convention is the withdrawal agreement between the United Kingdom and the European Union. and that agreement was reached 11 months ago. It entered into force on the 1st of February of this year, 2020, and it's been in the headlines the last few weeks. More on that in a few minutes. An example of an international convention that is multilateral, a good one, would be the Charter of the United Nations. Again, it's not called the Convention of the United Nations, it's the Charter. That's just a name we give to it, but it is an international convention. And there are now 193 states that are parties to the Charter of the United Nations. That's a multilateral treaty. You have to be invited to join it. There's a whole process under the Charter. It's not like any body can show up there and say, we'd like to join. And there are a few examples of states that would love to join, that behave like states in many respects, and are not able to join because they don't have the green light from the Security Council and the General Assembly of the United Nations. I'm thinking here of Taiwan, which is a state of more than 20 million people that behaves like a state in all respects, but it can't join the United Nations because of political agreements. And the same with the state of Palestine, which behaves as a state in many, many respects and is regarded as a state by many countries, and would be admitted if the General Assembly could take a vote, because the vast majority of members of the United Nations would agree with having Palestine join. But one of the members of the Security Council would never stomach it, at least one, that's the United States, just as one of the members of the Security Council would not allow Taiwan to join the United Nations. That's the People's Republic of China. So that's conventions. I'm going to say more about that in the second segment of this of these lectures for today. The second main source is international custom, and there you can see in the text we have two ideas. These are the two elements of custom. The first is a general practice of states. So to identify the custom, these are just means of identifying it, or evidence, as it's sometimes said, of custom. The evidence is we need a general practice. So we need to see that states are behaving in a certain manner, and there needs to be the second element, we say accepted as law, and that means that states have to be doing things. Their practice there has to be some indication that they're doing it because they feel that they're under a legal obligation to do it. So custom's a little bit more mysterious. Treaties are clear because they're in black and white. They're written down on paper. We can look at them, and then we have to interpret them. That has its own complexities, but at least there's a text, a starting point. Custom's a little vaguer because we have to have evidence of the practice, and more than that, we need to find evidence that it's accepted by law. But finally, general principles of law. As I said, this is what's closest to national law. An example from case law dating back a long time ago of a general principle is the obligation to repair damage that's caused by an unlawful act. And when the court ruled on this is the predecessor of the International Court of Justice, it said that this was a general principle of law recognized by all civilized nations. And you would find that the law of tort here in England and Wales differs from the law of tort in the Netherlands or in the United States or in South Africa or in Argentina or in Thailand, but that all of these countries have some sort of mechanism so that someone who is a victim of an unlawful act and suffers a damage as a result of it can obtain some form of reparation or compensation. So that's a general principle. As I say, it's more of a gap-filling notion, and we won't have a lot to say about it. It's really a very, very secondary importance. Our main areas of interest are conventions and custom, and these are, as I say, created by states in an international context. Now, there's no hierarchy here, really. You might say that paragraph D is of secondary importance because it doesn't say that it's a source, but rather it's a means for the determination of rules of law. I don't think there's any argument about the fact that paragraph D is in some way in a subordinate category. But amongst A, B, and C, there's no hierarchy. You know, we would apply a rule of interpretation if, for example, we have a customary rule, and then we have a convention between states that departs from the customary rule, then the convention would prevail over the custom. But that would merely be because the states had agreed to contract out of the custom. But it's not establishing a hierarchy between them. It's merely a question of legal interpretation of rules that are of the same level. I have a few. I'm going to go back to my slide because I have a slide here on the issue of hierarchy. There are two bodies of law, two types of law that are viewed as being hierarchically superior. One of them is a more nebulous notion because it too is not written down. It is like customary law in that sense, and the other is more written down. It's the Charter of the United Nations. And the Charter of the United Nations says that a treaty that's inconsistent with a provision of the Charter of the United Nations is not to be applied. That the Charter, in effect, overrules that particular treaty. So that suggests a kind of a hierarchy, although one might also say that that's simply a rule of interpretation between the two. The notion of jus cogens is different. I've given you the legal Latin here, jus cogens or jus cogens. I'm going to show you a few other Latin expressions as well. We love Latin, you know, in international law. Jus cogens is also the term that is synonymous with it is peremptory norms. And what this means is that these are rules that are genuinely hierarchically superior. The concept has been around for many decades, and it originally developed by analogy with contract law. Because contract laws, you know, you can make contracts, but you can't have a contract with an unlawful purpose that is contrary to public order. There's that notion that there are some things that cannot be made the subject of a contract. So, you know, you can make a contract to have your ears pierced, but I don't think you could make a contract to have your right arm chopped off. I don't believe that the court would enforce that, and they would say that that violates public policy. Well, this was the origin of the notion of jus cogens. So there is this idea that some things cannot be made the subject of a treaty. And the classic example, for example, would be slavery. Two countries couldn't make a contract that would provide that, for example, if they were to capture the slaves of another country, then they would have to give them back to the rightful owners. Of course, we don't have slavery today, really, anyway, but even 100 or 150 years ago, we would have said no, that treaty wouldn't be valid because its object is it can't be, it would be improper to have the law deal with that. There's a body that makes a huge contribution to the development of international law called the International Law Commission. The International Law Commission is a UN body made up of experts from around the world, and they spend several weeks every year debating international law on different topics. And about a year ago, they issued a report that they had been working on for 3 or 4 years about the content of jus cogens norms. And they were, if my memory serves me, only able to identify 6 jus cogens norms. One of them was the right of nations to self-determination, or the right of peoples to self-determination. Another one was the prohibition of genocide. A third one was the prohibition of slavery. fourth one was the prohibition of racial discrimination and apartheid. They were linked together. There were one or two others. I can't remember them now. You can look that up if you're interested. It's the International Law Commission. And so it's a very limited list of norms. And they did not even agree on including things that I would have included. I would think that the right of the women's equality and the prohibition of discrimination against women ought to be a peremptory norm as well. I can't see how states could violate that by treaty. And I would like to see, although this is a little more avant-garde, but it's certainly part of my perspective, I would like to see rights that we call economic and social rights included there. For example, the right to primary education, I think, ought to be considered jus cogens. I don't think states should be allowed ever to violate that by an agreement. So those are two sources of hierarchy of the norms. We don't see either of these things in practice very often. And recently, there has been a little bit of tension with regard to whether of these two hierarchically superior notions, one comes ahead of the other one. In other words, if the Charter of the United Nations prevails over a treaty that's incompatible with it, is a provision of the Charter of the United Nations or something done pursuant to the Charter of the United Nations that violates jus cogens norms, is that also invalid? We don't have a decision on this. Where this debate emerged was some of the anti-terrorist or counter-terrorism measures that were adopted, blacklists on people who were not allowed to travel, whose assets were frozen, and who had no legal recourse to challenge this. But there's a lot written on that, and if it's a subject that interests you, we can find some readings. Finally, in this segment, I'm just going to mention a few other Latin expressions that we will return to from time to time. Let me just go back to jus cogens. Let me mention jus cogens, although it's not written down in the strict sense, jus cogens is not a kind of super customary norm. It's something different. And as I say, it's really something that has emerged in the context of treaty law rather than of customary international law. Erga omnes is an expression that's often confused with jus cogens. It's somewhat different in nature. An erga omnes norm is about legal interest. And that means that all states, if an obligation is erga omnes, then all states have an interest in its enforcement and don't have to demonstrate that they're particular victims of the violation of the law because they have a role to play in ensuring its enforcement anyway. It's about legal interest. Opinio juris, I've actually already referred to what is opinio juris. Opinio juris is that element of, in customary law, there's the text, accepted as law, a general practice accepted as law. And the acceptedness as law we refer to as opinio juris. It's evidence that a state accepts the rule as being law. And finally, pacta sunt servanda. Pacta means the agreement, the treaty. It's about a treaty. Sunt means you're subject to it, and servanda, to agreeing with it. It means that it's basically a rule that you've got to respect your word. You make a deal, you have to respect it. If it's an international obligation, you have to apply it. And it's a rule applied to treaty law. I'm going to stop now, turn off the recording, and invite you to look at the next segment, either immediately or when it's more suitable for you. And I'm going to talk in more detail about treaties